Top of the morning to you, 2 minutes past 8 o'clock this Tuesday morning. It's the 22nd day in March 2022, and we are gathered here. We're gathered here to discuss national issues, to shed light on, whatever issue it is that is generating reactions from different quarters that affects you in whatever sector of the country, really. And that is our brief every weekdays in the morning from 8 to 10 a.m. On Panorama on the integrity station Splash 106.7 FM. Thank you for joining us. My name is Lola Meduteni. Good morning.
Good morning to you. Lola's told you what we do here from 8 a.m. to 10 a.m. The first part of the show is dedicated to discussing these issues, and we've tagged it Issue of the Day. While the second part of the show is where we take a look at the newspapers. You don't want to miss any part of this particular program. Welcome to Panorama today. My name is Guyega Olaniyi. And a quick reminder that we are streaming live on Facebook, so you can join the conversation there. If at any point in time you feel the need or the urge to drop a comment, you can do that as the program progresses. WhatsApp is also another channel through which you can also connect with us. 0817-555-1067. That is the WhatsApp portal. I'll be glad to take your contribution.
Absolutely. Twitter space as well. We're live there at Splash FM 106.7. The hashtag to use is Panorama as you tweet. And of course, don't forget that you can also listen to Splash FM, Panorama if you prefer, but generally the entirety of our programs, you can listen to them via different mediums. So even if you're traveling out of the city, out of the state, you can take us with you wherever you go. Do that by downloading our app, which you can find on either the Android store or the iPhone store. Just search for Splash FM and download. You can also listen to us via our website, www.splashfm1067.com. All right, let's get on with it then, now that you know the various channels by which you can get in touch with us. It appears that those who rejoiced that we have seen the last of news and controversies about the now signed Electoral Act, may have been just a tad premature in their jubilation. Recall that even as the president gave assent to the bill after much back and forth between the legislative and the executive, he had called to question Clause 84(12) of the bill, which reads, "No political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election," recommending that the National Assembly delete it. The president said the provision in this clause is in conflict with extant constitutional provisions.
A bill to do just that was brought up at the Red Chamber. However, the Senate rejected the bill to amend said section, as earlier requested by President Muhammadu Buhari. While this was ongoing, the Federal High Court in Abuja had barred the federal government and the National Assembly from tampering with the act, saying that having become a law, its validity can only be tested in court. Nevertheless, last Friday, a judgment by Justice Evelyn Anyadike of the Federal High Court Umuahia, Abia State, ordered the deletion of Section 84, subsection 12 of the Electoral Act by the Attorney General of the Federation, Abubakar Malami.
This judgment has now been drawing criticism from lawyers. So this morning we'll be engaging with a lawyer by the name of Mr. Festus Ogun to shed more light on the controversial Section 84(12). But before we do that, let's jog your memory and have you listen to what the president said exactly as he signed the Electoral Act and the reservations that he raised about said section.
Panorama.
Panorama.
Panorama. Panorama.
Panorama.
Panorama on Splash 106.7 FM.
Section 84, subsection 12 constitutes a disenfranchisement of certain political office holders from voting or being voted for at conventions or congresses of any political party for the purpose of the nomination of candidates for any election in cases where it holds earlier than 30 days to the national election. The section provides as follows. No political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. This provision has introduced qualification and disqualification criteria that alter various the Constitution by way of imposing blanket restriction and disqualification to serving political office holders, of which they are constitutionally accorded protection. The practical application of Section 84, subsection 12 of the Electoral Bill 2022 will, if assented to by operation of law, subject serving political office holders to inhibitions and restrictions referred to under Section 40 and 42 of the 1999 Constitution as amended. It is imperative to note that the only constitutional expectation placed on serving political office holders that qualify by extension as public officers within the context of the Constitution is resignation, withdrawal or retirement at least 30 days before the date of the election. Hence, it will be stretching things beyond the constitutional limit to import extraneous restriction into the Constitution on account of practical application of Section 8(4), subsection 12 of the bill, where political parties, conventions, and congresses were to hold earlier than 30 days to the election. Arising from the foregoing, with particular regards to the benefits of the bill, industry, time, sources, and energy committed in its passage, I hereby assent to the bill and request the National Assembly to consider immediate amendments that will bring the bill in tune with constitutionality by way of deleting Section 84, subsection 12 accordingly. Thank you.
All right, you heard the president there speaking on Section 84, subsection 12, which we will now be looking at in detail. With the aid of a lawyer, we've told you about the judgment that was recently passed by a federal high court in Umuahia, Abia State, ordering the AGF, Abubakar Malami, to delete said section, saying that it is void because certain sections of the Constitution, already bar public servants from, resigning, or insist that public servants resign before they run for office. But as we said, this has been drawing criticism from a lot of lawyers. So we're going to find out just what that is all about with Mr. Festus Ogun, who joins us via telephone. Good morning to you, Mr. Festus.
Yeah, good morning, Lola.
Thank you for joining us. Okay, so I've heard lawyers, use all sorts of legal jargon like locus standi, per incuriam, claimant, plaintiff, and whatsoever to say that this judgment, the judgment by Justice Evelyn Anyadike is, it's unnecessary or perhaps it's wrong. But break it down for us in simple terms, in layman's terms. What exactly is wrong about the judgment that was given by Justice Anyadike?
Thank you very much. Let me quickly say that with profound respect to the Honorable Court, the judgment of Justice Evelyn was reached or delivered par infuriam. When we say par infuriam in law, we mean it was delivered in error. And I'm confident that by the time the judgment gets appealed, it is unlikely that it stands the test of appeal. My position is hinged on the fact that Section 84, Subsection 12 of the Electoral Act, enacted in 2020, provides that a political appointee must relinquish his position before it can participate in primary elections, either as a delegate or an aspirant. As clear as that. Now, there is no contradictory provision in the Constitution that provides otherwise. Now, most of those that are against Section 84, Section 12 of the Electoral Act are saying that under the Constitution, by virtue of Section 66 of Section 1F, Section 107 1F, 137 1G, and 182 1G of the Constitution, a public official employed in the public service of the Federation of the State is constitutionally obligated to resign his office 30 days before election. But when we look at Section 318 of the Constitution, the section of law 318 of Section 1 of the Constitution defines who a public servant is, or what constitutes public service of the Federation, those that are employed in the public service of the Federation. And when you look at this section, you see that political appointees are not public servants under Section 318. So, the position of Section 84 to Section 12 is all about political appointees, while the position of the Constitution they are relying on is all about public servants. Political appointees are not public servants. In fact, this matter has been tested in our court. In the case of Oni and Fayemi, the Supreme Court made it abundantly clear that political appointees are not public servants employed in the public service of the Federation. In that case, what happened in that case? In the case of Oni and Fayemi, Governor Kayode Fayemi is the incumbent governor of Ekiti State, contested election and resigned his office during the period of contesting that election. Resigned his office as a minister barely 28 days before the election. He was a minister when he contested that election under the first administration of President Muhammadu Buhari. But he resigned his position barely 28 days to the general election in Ekiti State, to the gubernatorial election in Ekiti State. Now, Mr. Oni went to court to say, oh, Mr. Fayemi is a public servant. Therefore, the mere fact that he resigned his position 28 days before election is a contravention of the relevant section of the Constitution. But the Supreme Court said, no, that is not the law. That the mere fact that you are a political appointee does not make you a public servant employed, because you are appointed and not employed into the public service of the Federation. So, where the judge didn't make clear was that there is a fundamental difference, or there is a fundamental distinction between who a public servant is and who a political appointee are. A political appointee is not a public servant employed, because he was not employed. They were not employed. They were merely appointed. And so, it is impossible for you to say that Section 84 of Section 12 that was enacted in respect of political appointees is void, because there is nothing in the Constitution that mandates political appointees who are not public servants to resign. Not just that, we also have the case of Adamo and Takori, where the Court of Appeal held that political appointees like an attorney general is not a public servant employed in the service of the federation, and therefore political appointees are not caught under the 30 days rule. So it is not, when it comes to a political appointee, you need not resign 30 days because the constitution was not referring to a political appointee under the relevant section of the constitution that were caught under the 30 days rule. No. What the constitution was talking about are public servants, and political appointees are not public servants. So I think those that are making this argument seem not to understand or appreciate the position of the law, or maybe they are merely mischievous about what the law says. Now, let's assume, without considering, that the relevant section of the Constitution relating to the 30 days rule in respect of public servants is applicable to political appointees. We could as well make the argument that given that the relevant section talks about resignation 30 days before the election, we could as well make the argument that the election talks about, since that the Constitution never defines what the particular election they are talking about, we could as well make the argument that because the election they are talking about is the primary election, because the Constitution never mentioned that it must be the general election. We could as well make the argument that, the 30 days before election that the Constitution was talking about was not the general election, but the primary election. Because the Constitution never said the primary election, and the Constitution never said it was the general election. We could as well make the argument that it could be the primary election. But the argument cannot even arise because constitutionally, political appointees are not covered under the 30 days rule meant for public servants employed in the service of the federation, because they were not employed in the service of the federation. So,
another point of conflict has to be about the court asking the Attorney General to expunge that part of the act, which has also been, causing quite a bit of an argument as well. That's on one part. Then, if it is as simple, as clear as you have described it, on what basis then do you think that Justice Evelyn Ayadike based her judgment on? So, two parts now. The part where the court also asked the Attorney General to expunge that part from the acts, is that right? And secondly, on what basis do you think that the justice or the judge based, her judgment on?
Look, thank you very much. Everything about that judgment calls for worry. Everything about that judgment is deeply suspicious and disturbing. But I have never seen all my life that a court would direct that a position of the law, a validly enacted law, be expunged by the Attorney General. It is rather strange to me. The decision is a declaratory judgment, or should be a declaratory judgment. The court will only declare that position of the law is void as a result of inconsistency with the provision of the Constitution. That is the best. That is at best what the court should have held. But to say that the Attorney General, who is an interested party, to unilaterally expunge a part of the law validly enacted, is to me usurping the statutory duty of the National Assembly. The court is not empowered to direct the Attorney General to expunge a whole part of the law. No, the court can only declare the particular provision of the law as illegal and unconstitutional, but it has to remain here. Now the Attorney General is saying that by the time the federal government will print that particular law enacted by the National Assembly, now that particular provision will be expunged. That is encroaching on the legislative power of the National Assembly guaranteed under Section 4 of the Constitution. That is not acceptable under our constitutional democracy. Again, it beats the imagination that a matter that ought to take some months took less than 10 days from the point of filing the matter down to the point of delivering judgment. It took less than 10 days. The matter was filed on the 8th of this month, and the judgment was delivered on the 18th. When did they file the application? When was the application replied? When was the date for hearing? When did the court adjourn for judgment? Again, why did the plaintiff in that matter, why did the plaintiff not join the INEC, who is mandated to conduct election in Nigeria, whom that election would deeply affect, because they are the one that will carry out the provision of the Electoral Act, that will implement the function of the Electoral Act? Why were they not joined as a party to that suit? Why was the National Assembly not joined as a party to that suit? Because these are the important parties, even more than the Attorney General. The Attorney General ought to be a nominal party under our extant law. Because the National Assembly made the law. They were not given opportunity to enter the fence in that matter. They should have been joined. In fact, the court should have ordered that they should be joined in that suit. Now, is it not strange again that the Attorney General was defeated in court? And for an Attorney General that is notorious for disobeying court judgment, is it not suspicious that the Attorney General is saying they are going to obey this kind of controversial judgment? So it calls to question the circumstances that even led to the delivery of the judgment in the first place. And it's going to put us in a lot of trouble if the judgment is not quickly rescinded, not just because it will hurt the integrity of our electoral process, but it's going to set a very perilous precedent where an Attorney General can whimsically and unilaterally find a way to expunge a position of the law, using the judiciary as a tool for his own favor. Why should a political appointee be holding a political position at the same time contesting to govern or to represent our people? Why not resign the position you are holding before you go ahead to contest another election? Is it not a form of greed? Political greed. You want to remain in the position that you have been appointed, and at the same time you want to contest election. Will you be able to focus on the business of governance while running elections? You see that that position of Section 84/12 is in the interest of the Nigerian people. It's in the interest of the common man. But selfish and greedy politicians will not allow you to see the light of the day. If I'm holding a position as a minister and I want to contest election as a member of House of Representatives, representing the people of my constituency, why can't I just relinquish that position, that political appointment that I'm currently holding, just to focus squarely on the election that I intend to contest? It is just to sanitize our polluted political atmosphere. That is the purpose of Section 84/12. But mischievous politicians who do not mean well to the generality of our people are finding ways to expunge it from our law. We are going to receive that by all legal means possible, because their position is not only factual, it's not only legally inaccurate, their position is constitutionally invalid and cannot stand the test of public morality. These are the issues. But at the end of the day, the people of this country must quickly rise so that the Attorney General will not go ahead to gazette that declaratory judgment or directive of the Federal High Court. That judgment cannot stand the test of constitutional validity.
Right. Okay. You've raised you've raised questions with the entire process leading up even to Justice Ayadike's judgment. You've, poked holes at the speed with which the judgment was passed, the fact that, INEC and National Assembly were both bypassed. And your position aligns with that of several lawyers who have also criticized this judgment and the whole process. Mr. Deborah, Mr. Falano, a lot of, prominent lawyers have also said the same things that you're saying. But what does the judiciary intend to do? Because the judiciary under this administration, particularly under the, shall I say, helms of the Attorney General of the Federation, has been questioned a lot. Its integrity, its independence. So what do you intend to do? Perhaps what do you, maybe as the Nigerian Bar Association or the lawyers who find fault with this judgment, what do you intend to do? What's the next step now that you've said, there are clearly discrepancies in this judgment?
The options that are left for the people of this country is to majorly call on INEC and the National Assembly to quickly appeal that judgment as an interested party. Again, it is difficult because some of us have undertook to challenge the judgment, but it is a bit difficult. Why? For you to challenge that judgment on appeal, for you to appeal that judgment as an interested party, you must show your interest. How are you an interested party? Are you a political party? Are you a political appointee who intends to contest election? Are you INEC? Are you the National Assembly? If a political party who is an interested party decides to challenge the judgment as an interested party, fine. If as a political appointee you want to take the path of honor to challenge that judgment, again, you can go on appeal as an interested party, as a political appointee. But an ordinary citizen might not be granted the leave to appeal because there might be insufficient interest or legal interest. However,
if that is the case, then on what basis the individual who took the particular who filed this case in court, on what basis was he also an interested party? Just to clarify that point, if a regular citizen cannot appeal this because of interest, just like you have said, then on what basis did this particular lawyer appeal that part of the Electoral Act?
Well, it's equally strange to me because these are issues that should have been raised if the important parties or the relevant parties, the INEC and the National Assembly, would have been joined as a party to that. These are the issues they would have raised. The plaintiff in this suit is said to be a chieftain of a political party. A chieftain of a political party. If you are a chieftain of a political party, the question then the answer, how are you an interested party? It would have been a different case if it was this party that instituted that action. It would have been a different case if it was this party that instituted the action. However, the facts are not completely clear whether he is a political appointee as we speak. So that is the difficulty. However, I think if other citizens deem it fit, they could institute their actions, because in this current action that made for the controversial judgment, INEC was not joined as a party. The National Assembly was not joined as a party. So while we will continue to mount pressure on the National Assembly and INEC to ensure that they quickly and hurriedly go to challenge that judgment as an interested party, I would also implore citizens to go ahead to seek an interpretation of that particular position of the law. But they may be faced with serious hurdles going forward. But it has always been that if we try, we may win. If we fail to try, we have lost. But individuals can equally seek an interpretation of that position of the law by appropriately joining INEC and joining the National Assembly. By a lot of our people.
So I also want some bit of that bill was signed into law by the president. A federal high court in Abuja, asked the National Assembly and another court now saying it's against or I believe that's how you lawyers say it. Giving contrast.
I think it's deeply painful that we've got into this court of ordinary jurisdiction. But the ratio, the reason behind it, they are political interference in our judiciary. It seems to me that they are of how the cases are speedily heard and determined. Some of us filed suit. I have a matter at the Federal High Court in Abuja. The matter has not been heard by court. A date has been that has been languishing in detention of a loan judgment. So why is it that priority this is why I've always made the argument that we need a justice system that works for all and not need to quickly reform our justice system before it consumes us. That looks like a justice system. Because what is just in me is that not a sort of miscarriage of justice. These are the fundamental issues. Again, President Muhammadu Buhari needs to answer serious questions too, with proper respect. The reason I'm saying this is because why making opposition to a particular aspect of the law. If the president was not comfortable with that section, why should he sign it into law? The president went ahead to sign the bill into law and now say, no, I'm not comfortable with it. Not sincere when he signed that bill into law. It was maybe as a result of the pressure from activists and civil society. So at the end of the day, on the issue of contradictory judgment that has exposed the judiciary, the tempo of why our justice system needs to be quickly reformed in the interest of our people. Cases should not be given undue priority. Political cases, yes, the more does not necessarily mean that the very principle. These are the issues.
Right. Okay. Well, we are in conversation with Mr. Festus Ogun, who is a barrister and solicitor of the Electoral Act, which the president had objected to, even as he signed the Electoral Act, and subsequently a judgment emerging from a federal high court in Umuahia, Abia State, given by Justice Evelyn Anyadike, has now voided that section, saying that it is, it overextends or overreaches, given that a certain section or certain sections of the Constitution already bar public servants from, running for positions without first resigning from their position. But that is drawing criticism from several lawyers, and that's why we engaged, or we are in the process of engaging Mr. Festus Ogun on this matter. You can let us know what you think of this, your questions, your comments, your opinions, your contributions. We have Facebook, Splash FM 106.7 FM, and we have Twitter, Splash FM 1067. We also have WhatsApp, 0817-555-1067. We're hoping to simplify this and make it easily digestible for you, so you can know what it is. What is all the buzz? What is all the fuss about Section 84, subsection 12? Now, before we begin to take telephone calls, we'll get to your calls shortly. Please be patient with us. I'd like to ask Mr. Ogun, is this judgment binding, given that there are so many questions raised with it? I mean, given that the entire matter, the process leading up to it.
Painful as it is, it is binding. Or until that particular judgment is overruled by the appellate court. So as it stands, we can make the argument, or it is the law, that the judgment stands. The judgment stands until it is overturned or overruled by an appellate court. And that is why our people must try as much as possible to call on the national. Some of us will write the National Assembly very soon. For the National Assembly and INEC to quick
calls now, 0817-555-1067, which you can call, and also 50-1067, 0817-444-1067. Talk to us. Good morning.
Hello, good morning.
Good morning.
You and your guest, we thank you for the job well done. On this administration, we are disappointed. We see, because we see the what's so called the professor of law are behaving like this instead of taking our guest today. Please, I want the and the House of Assembly to quickly go to court to bring all the up now and pressurize the INEC and the to the court. So instead of not to waste the time, and the judge too should be reported to the NJC. Look at how they beat to the PDP then. We supposed to be.
For your submission, 0817 5 0817 444 1067 0704 for
I'm calling from Abeokuta.
Olani Marshall. Thank you for calling. Go ahead.
Thank you. Actually, there is one lacuna that seems to needs to be explained better for the state. But could you please ask this officer to explain in detail what is the difference between the civil servant